Now to the courts. The High Court has declared the Social Health Insurance Fund unconstitutional. While delivering their judgment, Justices Alfred Mabeya, Robert Limo and Freda Mugambi gave Parliament 120 days to amend the law establishing the fund. And as Ruth Wamboi reports, the court argued that the program had overburdened salaried individuals, thus creating a disparity in the contribution.
It is back to the drawing board for the government after the court annulled and voided the Social Health Insurance Fund barely 2 weeks after registration began. In its judgment, the three-judge bench led by Justice Alfred Mabeya stated that there had been no public participation in the formulation of the new health program.
The entire Digital Health Act 2023 and the entire Primary Health Act 2023 are all unconstitutional for the reasons set out in this judgment.
The bench poked holes the haste in which the act was legislated.
The primary objective is to give effect to Article 43(1)(a) of the Constitution. There is evidence that the former legal framework, that is the NHIF, has failed to realize those rights. In any event, it is unsustainable.
The judges said they extend the two sections of SHIA have not made exceptions to the right to emergency medical services. The same cannot stand the test of constitutionality.
The current section was introduced ignoring a key principle under Article 201, which emphasizes on the need for openness, accountability and public participation in financial matters.
However, the court has given Parliament 120 days to amend the law establishing the fund.
We have also appreciated that the suspension may create a lacuna on matters health in this country, even as parties seek to comply with our judgment. It is for that reason that we are inclined to allow a temporary stay of the suspension for 45 days as requested. However, we hasten to add that the stay granted shall not affect the suspension of sections 26(5) and 27(4) of SHIA.
The decision comes after NHIF notified Kenyans of the impending shift rollout, which was set to begin on October 1st.
Pertaining to that universal health care. And therefore, the High Court has said, you National Assembly, you the Senate, revisit these, start from square A.
A petitioner, Joseph Aura, through lawyer Harrison Kinyanjui, had opposed the mandatory shift registration for accessing government services, citing its discrimination. With the court giving its judgment Friday, it has ordered the state to ensure that public participation is done in both the national language, that is English and Swahili. Ruth Wamboi reporting for Easy Friday from Milimani, Locals.